Good morning or good afternoon, everyone. Thank you for joining us for today's session of Leaders in Law. Before we begin, we have a couple of quick housekeeping announcements, and then I'll introduce our speakers for today. The first housekeeping announcement: you may have noticed that you're currently in listen-only mode. This is to cut down on the amount of background noise so that it's easier for everyone to hear our presenters and to make sure that there isn't any background interference. However, you are still welcome to ask questions. To ask questions during today's session, on your GoToWebinar pop-up, there will be a button that says questions. Depending on the size of your pop-up, it might just have a question mark on it. Please feel free to ask questions at any point during today's presentation using that pop-up. Second quick announcement. This is a reminder that today's session is not for CLE credit. Fastcase does offer webinars for CLE credit on legal research, and you're welcome to sign up for those at our main website, fastcase.com/support. All right. So with those two quick housekeeping announcements out of the way, my name is Erin Page, and I am the Senior Law Librarian on staff with Fastcase Legal Research. My co-host for today's event is Morgan Wright, the Editor-in-Chief of Full Court Press. You want to say hello, Morgan?
Hi, everyone. Thanks for joining us today.
And of course, we have our wonderful presenters for today's session. We have Professor Oppenheimer and Professor Noel, both of whom are the co-editors of the Global Me Too movement, and will be speaking to us today about the Me Too movement and its impact on the law. All right, so with that fun intro, professors, is there anything you would like to say as an introduction before we ask our first question?
Can I just say a word of thank you for what a terrific job you all did in publishing this book, getting it out so quickly and making it so well distributed, and the editing the editing assistance we got from you, it was really marvelous. And we look forward to continuing to work with you on future projects.
Thanks so much, David. Thanks to both of you. It was really a lot of fun to publish, and a topic that was of great interest to me personally, and just an exciting project to work on at this point in my career. So thanks for taking a chance with Full Court Press and our budding publication imprint. So with that, I'll get started with some of the questions that we had, starting at the beginning of the Me Too movement. We can all see that the Me Too movement, at least the underpinnings of it, the beginnings of it, sort of the ideas that go back to the 70s and earlier. But to your mind, what are some of the key historical moments, recent historical moments, that really kicked off the hashtag Me Too movement as we know it today?
Well, the movement started, the hashtag, as I think most people know at this point, was started by Tarana Burke a number of years before the revelations about Harvey Weinstein and the articles that were famously in the New Yorker and the New York Times. And if you go around the world, there are events, including here in the United States, that far preceded the revelations in 2007. The difference, though, I think in 2007 was that at that point had social media that made it possible for women anonymously or with their names attached to it say that they had been sexually harassed. So it did create a worldwide movement, and in most places there were places where you didn't really see much of a murmur about it, or places where there was a significant backlash almost immediately. But it really was the first time there was a worldwide movement happening all at the same time. And it was because of the notoriety of this Hollywood mogul.
Yeah, and I guess I would just add that the problem of sexual harassment precedes even the term sexual harassment. And the recognition in the 70s that this was a legal problem that could be given a name and given an identity within anti-discrimination law. was the first breakthrough. The recognition that this was not simply tortious conduct, but that this was a form of sex discrimination. And as courts began to agree and recognize that, and now it's very much a part of international law through the ILO, that harassment, including sexual harassment, is a form of sex discrimination. And we find it in the law of the European Union. We find it, of course, in US law. We find it in national law around the world, and now in international law again with the ILO, and also with the Convention on the Rights of Women. Each of those steps represents a legal milestone. And then, as Anne was saying, the development of social media, making it possible for women to bystep the legal process and instead go public, truly changed this revolution and made possible the social movement of the Me Too movement.
To that end, do you think that the Me Too movement happening in the United States was an inevitability, or was it just the right moment for, you know, the stage was set for this sort of thing to fire off because of just the technology that was there?
I think the stage was set probably with the election of Donald Trump and all the revelations that had occurred about his own particular history with women, you know, bragging about molesting women and then not seeming to have any consequences. And you saw that with the women's marches that occurred, not only in the United States, but in other parts of the world. So, I mean, it didn't hurt that when the revelations about Harvey Weinstein came out, he was accused of sexually harassing so many women, and they were women that people knew from watching films or television shows. And they, you know, they were beautiful, gorgeous women, but nonetheless, they were describing instances of just awful abuse. And people could relate to that. I mean, I think it was equivalent to, you know, the spontaneous outpouring when we all watched the video of George Floyd's murder. There's just some things that just strike a chord, and people start reacting. And I think it was a moment that people were primed for here, women were primed for here, but also around the world.
I'm glad that Anne mentioned George Floyd, because I think that the Me Too movement and the Black Lives Matter movement have been enabled by social media and the ability of people to go to others without having to rely either on legal process or on the established media. And it's part of this, I think, technological revolution, which I guess Fastcase is also part of, in terms of upsetting norms. So I don't know that any particular movement is inevitable, but certainly the stage was set both for the Me Too movement and the Black Lives Matter movement by the ability of people to communicate through these new methods.
That's an interesting point, actually. So there have been preceding social movements that have had vast impacts on the law. Many of them have been termed as consciousness-raising movements, or environmental raising movements, or just sheer awareness movements in the past. And some of the crux of the Me Too strategy has been assuming that there has been a lack of knowledge or a lack of acknowledgement about the sexual harassment and assault and issues that have been involved with this movement. How does this compare to those earlier movements? Is there a major difference beyond the social media availability now? Is that the main difference between the current Me Too movement and these older awareness movements? Or is there any other fundamental differences that you know of?
You know, we had spent a lot of time in the United States trying to grapple with this issue. Catherine McKinnon, who wrote the first chapter of our book, was a real pioneer in defining what sexual harassment was, and then working with other women attorneys to establish some good cases initially around seeing it as a cause of action, as a form of discrimination. And there was a whole cottage industry building on doing anti-harassment training. And in California, where David and I are based, the California legislature really worked hard to, create a model sexual harassment training legislation and a lot of good remedies for women who were victims of sexual harassment. But what we saw with the Me Too movement was that all of this hadn't necessarily worked. And so those of us who've been working on it for a while felt like, well, wait a minute, what are we doing wrong here, and what needs to happen? And the social movement put the issue front and center and empowered women in ways that all of these laws that we had been working on for so long did not. It really put power behind what the law could do.
Yeah, just to add to what Anna's saying, and I think the example of the California legislature is a good one. There's often this interplay, this sort of dance between law reform and social movements. So, for example, if we go back to the civil rights movement of the 1950s and 60s, it was both a very important social movement, led to the extent that it was led by Dr. Martin Luther King, from a point of confrontation and moral confrontation, and it was in part a religious movement. And then you had the law reform movement very much being led by Thurgood Marshall and the NAACP. And they were at times at odds. I mean, Thurgood Marshall sometimes complained about Dr. King ignoring the law. And King, in turn, was frustrated at times with Justice Marshall, well before he was Justice Marshall. And yet their work each boosted the work of the other. And I think that's true in the case of this movement as well, that the movement for legal recognition and then reform as we see legal problems with sexual harassment law is deeply affected by the social movement against harassment.
Speaking a little bit about the cultural environment that Me Too has created, I do think we need to address some of the opposition to the Me Too movement, or the quote Me Too backlash that has occurred, with some people saying, maybe the momentum of the Me Too movement has gone too far, is too all-encompassing, and there's some significant collateral damage here for people that might not necessarily be bad actors. How would you address that sort of opposition or criticism to the movement?
There's, we've had, David and I working with the Berkeley Center that David founded, the Berkeley Center for Comparative Equality and Anti-Discrimination Law. We held a couple conferences in 2018 and 2019 and 2020, 2018 too. Sorry, we've now had 3 conferences. And one of the issues that comes up is due process, and whether people are by being named as alleged harassers denied due process. And sometimes I think that is true. No one seemed to worry so much, as several people pointed out at our conferences, about the due process of women who were not believed, but the due process of alleged harassers is brought up. But David can talk, and ended up writing a chapter to be the last chapter of the book when it became so clear that in other countries besides the United States, defamation lawsuits were a huge inhibiting factor for women coming forward and asserting that they had been harassed. It was really a silencing way of preventing women from taking on their harassers.
Yeah, around the world, defamation law has been weaponized as one of the weapons of the backlash against the Me Too movement, and has been very successfully weaponized. If you look at Australia, where women are very much afraid to publicly talk about their experience of being harassed after the Jeffrey Rush case, where he received the largest verdict in a defamation case in Australian history. If you look at Israel, and I hope readers will look at our Israel chapter written by the former dean of the University of Tel Aviv Law School, who's now sitting as a justice on the Israeli Supreme Court, and her own experience on the court that she writes about, and the way in which defamation law has been weaponized in Israel. If you look at Egypt, where criminal defamation law has been weaponized to silence women who report on harassment by jailing them and jailing members of their family, including their children. The legal tools that have been used as backlash, and even in places like the Czech Republic, where the only sign that there's any recognition that there has been a movement against sexual harassment is the backlash movement. Women in the Czech Republic have been very much fearful of speaking out, but it hasn't prevented men who have opposed any right to speak out or any right to be free of harassment from claiming that they're being silenced when there aren't even any complaints being made. This is a problem around the world. So yes, due process is important, but the backlash against the movement to resist sexual assault and sexual harassment is a very strong movement, and one which I think we have reasons to be fearful about in terms of women being able to experience true equality in the workplace and at schools and universities.
Absolutely. So following up on that theme of defamation, and as you just mentioned, defamation has to some extent been weaponized as a part of the backlash against the Me Too movement. One of the things that you mentioned in your portion of the book was the possibility of there needing to be limitations or certain types of defenses removed or encouraged in the process of defamation suits and litigation. Can you speak a little bit more to that type of issue? What are the tactics that are being used in these defamation suits, and how can or should they be limited in the future if we are trying to remove some of this weaponization?
And you want me to start on this one?
Yes, please. I think that you should. Yeah.
Sure. So I think the place to start in understanding why American defamation law, because it has been constitutionalized, because we have the protections of the First Amendment, is very different than defamation law across most of the rest of the globe. And the place to start is with the attempt in the 1960s to end all newspaper coverage of the civil rights movement by those who were opposed to that movement in the South. And they did so through defamation cases against Dr. King and other leaders of the civil rights movement. And they began almost immediately receiving $500,000 and $1 million verdicts. And that was in 1960s dollars, so a great deal more today. Not only against the leaders of the movement, but against the newspapers who printed advertisements in support of the movement. So New York Times v. Sullivan, had it gone the other way, would have meant that no major newspaper and no major network would have covered the civil rights movement anymore. And I think that means that the civil rights movement would have largely failed as a social movement that led in turn to law reform. So that's what's happening in the rest of the world, where we don't have the constitutional protections that we have in the US because of Sullivan v. New York Times.
I just wanted to add two things. One, David gave a bunch of examples from the book about how defamation has been used to silence people. I find one of the most ironic chapters France, where you had Emmanuel Macron getting up very early on in 2017, saying France was going to lead in terms of laws that were going to reform how women could assert harassment, and the French government planned, was built on equality, and it was really going to take this issue seriously. And then a year later, you had a journalist who had said that she was harassed by a very prominent French politician who said that he loved her breasts and he wanted to make her come all night. And she said that he had said this to her, and he acknowledged that he had said it to her. But nonetheless, he said his reputational damage went far beyond. Once he gave her an apology, she should have let it go. And the fact that she publicized what he said, in other words, he acknowledged the truth of the statements. But nonetheless, the court had this big settlement. This big judgment against her. So, it's just one example of how this issue is used around the world. I want to say one more thing about David's chapter and the benefits of the book. The book it's designed not only for us here in America, but for an international audience, and it gives activists in other places ideas of what they can do to counter harassment. David's chapter is a shining example of that, but there are also examples in the book of other things that have worked in some places that we could use here. More examples of alternative dispute resolution in some countries, examples of employment tribunals that make it easier to bring lawsuits. And then we utilize the Brain Trust, which is the Berkeley School of Law, to have a number of chapters on ideas that we're using here in America on getting more diversity on corporate boards, for example, on eliminating non-disclosure agreements, which prevent people from saying that they've been harassed, which was a huge problem in the Harvey Weinstein cases, how to do good workplace investigations, and what doesn't work, which is just having a policy and doing like a little check the box kind of harassment training, which doesn't work at all, we learned. Even though I had worked really hard on regulations to make people do those, to do that training, turned out it didn't work at all.
Another word about President Macron, because when the Me Too movement in France resulted in women naming names, he was deeply offended by that. And he was so offended that he compared them with the collaborators with the Nazis who turned over their neighbors who were Jews to the Nazis to be deported to the death camps. And he said that to accuse someone of sexual harassment through a system other than the legal system was the moral equivalent of sending somebody to their death at Auschwitz. A statement that I find such horrifying hyperbole, but not atypical of the backlash against the Me Too movement.
Speaking a bit more to that global perspective, I think that's what's so valuable about this book is there's so many different countries represented in the book, and you can kind of step back and see the through lines of how we can work together to strategize globally about these issues. And that's really the real value of the book, in my opinion. So can you give some examples of what has arisen out of the book, out of being able to kind of get the macro view of what's happening around the world and what's effective and what isn't in battling these types of harassment and discrimination issues?
It's interesting. There's a wide variety of responses to harassment and a wide variety of governmental responses, societal responses, and how bad it is to be female in a lot of places in the world. So just starting in the Americas for starters, Canada has just done an amazing job. You know, we've had a lot of response. When you move south, the most noteworthy thing for me editing the chapters, we had chapters of Mexico, Colombia, Brazil, and Argentina, was just how horrifying the rate of what they've termed femicide is. Domestic violence that results in murder of women. And so one of the big issues there is not so much harassment at work, but just women, you know, trying to prevent themselves being killed. And then when you move to Europe, there's a wide variety of countries who really address the issue for better or worse. England and the United Kingdom did a big inquiry on non-disclosure agreements to get rid of them. And you know, we've talked about France already. Sweden had 75,000 different hashtags of every profession you can think of in Sweden, where people are going, "Hey, I've been harassed too," which is interesting because I think we think of Sweden as a sort of model of equality, not necessarily. In some countries, the Czech Republic and Italy as two notable examples. David mentioned the Czech Republic already. They had almost instant backlashes. The Czech Republic held a hearing on sexual harassment, but it was just all these men coming forward and saying how ridiculous it was, mostly. And then in a lot of countries, and this includes a lot of countries in Asia and Africa, the people who feel empowered enough to talk about the fact they've been harassed tend to be young women in academia. That's true in China. That was true in Nigeria, you know, in our talks. In some countries, it became an issue when some notable person, you know, similar to the Harvey Weinstein scenarios, came forward and said they'd been harassed. That was true in Japan. Shiori Ito is one of the Times Women of the Year, and she was a prominent journalist who alleged that she'd been harassed. It also was the case in South Korea. So there are a variety all over the world instances. You know, it's in a lot of countries, what's made a huge difference is CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. America is not a signatory to that convention, but most of the rest of the world is. And often the very first steps that developing countries took to address the issue of sexual harassment was to conform with the requirements of signing on to CEDAW.
And to drill down using CEDAW and comparing the United Kingdom and the United States with the CEDAW requirements, in the UK, a person complaining about sexual harassment has to prove lack of consent, which means that consent is presumed and the burden is on the claimant to show that there was no consent. In US law, the US Supreme Court rejected the consent defense in the Vinson case, but in the US, the claimant has to prove unwelcomeness, somewhat easier than proving a lack of consent. But again, because the burden is on the plaintiff, that means that the presumption is that it was welcome, and the plaintiff has to prove that it was unwelcome. International law under CEDAW asks the claimant only to prove coercion. So even a plaintiff who consented, and even a plaintiff for whom it was not unwelcome, if she can prove coercion, she has met her burden. 3 different ways of erecting a legal standard, and each makes a difference in terms of the difficulty of proof. And of course, what people I think fail to understand about sexual harassment law is how hard it is to prove a claim of sexual harassment.
The other thing, you know, that I got reading all these chapters and looking at international law is a shift of thinking, which is why I think it's so useful to do comparative equality work. So instead of thinking of it, as I think we tend to in the United States, as an individual problem of, you know, a man and a woman getting harassed, that it's more a relational dispute. rather than looking at it as a way of structured inequality, where you have very often the male in a position above the female. And this is just another example of a way that she is told that she does not have the same rights as the male does, and she is put at a disadvantage. And so it's not just an individual problem, it is more a group problem, a societal problem.
So before we ask any further questions, just a quick reminder to our audience, questions are welcome, and please feel free to enter them on the questions button in your GoToWebinar pop-up. We'd love to ask questions directly from the audience, so please feel free to enter them at any point during today's presentation. And before we ask any other questions, can both of you tell us a little bit more about CEDAW for members of our audience who aren't familiar with it already?
David, you want to talk about it?
I was going to say, Anne's the expert on CEDAW.
I can tell you it was enacted in 1979, and most of the world, except for the United States, which never likes to sign on to anything international, or if it did, it certainly doesn't now under the Trump administration. It's a convention which, I mean, it would be the equivalent of the Equal Rights Amendment if that had passed. That you are, and ERA was the actually the model for it. And so ironically, we never ended up getting that final state to pass ERA. The international community took it up, and what it resulted was the convention.
You know, it's interesting, Anne's point that the ERA was the model. The United States, in addition to exporting grain, and it used to be steel and coal, and the various other things we export, we are a net exporter of law. Much of the world looks to the United States as a source of law models. And US anti-discrimination law has been enormously influential around the world, both in terms of the statutes that we passed in the 1960s and the interpretations given to them in the 1970s and beyond. The Griggs case has been adopted around the world, often with reference to the Griggs decision. And it was when I started studying comparative equality law, and I was studying comparative affirmative action, and I started reading the decisions of the Indian Supreme Court, I was so shocked to find these long discussions of the jurisprudence of the US Supreme Court, and long discussions of the Bakke case, for example, and whether or not India should adopt the Bakke case as its model for affirmative action. And ultimately, when the court said, no, we reject the Bakke analysis, the need for the court to explain at great length why they were rejecting the Bakke analysis. And we're so unaccustomed in the US to seeing anything like this. But as you read opinions of the European Court of Human Rights or of the European Union High Court, there's always a section on comparative law where the court asks, how is this problem resolved in other legal systems? And that's very alien to us in the US, but it's very much a part of the law. And often they look to us, even though we're not looking to them.
Just to give you a few more specifics about CEDAW, I mean, the framers of it looked at every way that women were disadvantaged. So as a form of discrimination, looking at laws that might have prevented women from, having full participation in government, in society, on jobs. It talks about sex trafficking. It talks about child marriage. It's very comprehensive in looking at almost every way that that women might be disadvantaged, and I definitely recommend people looking at it. Wikipedia has a pretty good summary of it.
Excellent source. Okay, so speaking of international law, just for a moment, many countries have many different legislative proposals and current legislation that impacts the Me Too movement. Sweden has a very detailed set. Other countries like the Czech Republic, much less so, to pretty much non-existent. However, one of the things that was noted in many of the chapters of the books is that there's a great deal of difficulty in getting prosecutions and successful prosecutions to happen under any legislative efforts, regardless of how detailed they are. Is there a successful or a global response that you would consider successful in terms, not necessarily about the policy, but the legislative framework for dealing with these issues, for dealing with harassment or other Me Too related issues? Any of them that you would consider a success or a model?
Well, I'm going
And
to
you need-
shout out California here.
Yeah.
California in 2017, 2018 had female aides in the California legislature come forward and say, hey, we've been harassed. And feminists who've been trying to get a number of bills through the California legislature then pounced and put a whole package of bills together, and the California legislature ended up passing every single one. So we have fabulous laws here. It's definitely based on a litigation model. It's not based on an equality model. It's based on sort of our existing statutes. Another country that did a really good job was Canada. Canada has awesome laws. Canada's just, amazing. And in the rest of the world, it was sort of a mixed bag. I mean, they had these wonderful inquiries with to get rid of non-disclosure agreements in the United Kingdom, fabulous testimony given, including by Eileen McColgan, who wrote our UK chapter. And that's just sitting there. They haven't done anything with it. It's just sitting there. It's, they say, well, they're too busy worrying about Brexit and now the pandemic. Australia did a fabulous inquiry about all the ways they were going to revamp their sexual harassment laws. And then the administration they thought was going to come in, Labor, didn't. The Conservative administration came in, and it's just sitting there and they're not doing anything with it. So there are some good examples out there, whether they were implemented or not so much. But, Canada, yay. Canada's great.
I co-edited a book 3 or 4 years ago with Marie Marcotte-Brun of Sciences Po in Paris on the effectiveness and enforcement of anti-discrimination law. And we asked authors from around 40 countries from around the world who were associated with the International Academy of Comparative Law to prepare reports on the enforcement and effectiveness of anti-discrimination law in their country. There was an enormous diversity of approaches to anti-discrimination law, from using the criminal law to using civil law and civil litigation, to using administrative law and administrative bodies, to using special courts, including special labor courts, to emphasizing mediation or conciliation or ombudspersons or community resolution or special constitutional courts in Colombia and special standards in South Africa that focused on the fairness of the discrimination. And yet the unifying conclusion of all of the chapters is that discrimination is very difficult to prove, even as we see it all around us. And that discrimination law, whatever form it takes, is a great social challenge in terms of the enforcement of that law because of embedded systems of bias, both conscious and unconscious, that operate to continue to put men in charge over women, and in a variety of different contexts to racialize and otherize various groups within societies. So in the US, systemic racism and white supremacy. In other states, it varies in different ways, but everywhere, these laws are very hard to effectively enforce.
I want to speak a little bit about sort of your process in putting together the book. We had a question from the audience that said, how do you feel about this achievement of creating the book now that you've finished the process? And how has that differed from when you first set out to create the book and the initial idea that you had on how it would go?
We had a conference in 2018 in response to the Me Too movement. And we had at that conference 7 international scholars who were talking about harassment in their countries. And David, you're going to have to help me out, but China, the UK, the United States, of course, France, and I'm forgetting where the other people are from.
Brazil, Turkey, South Africa?
No, I'm talking about the first conference. Anyway,
right.
Doesn't matter. Anyway, after that, we were patting ourselves on the back because it was a very good conference. And David said we should do a book. Do you want to edit it? And I said yes. So we started working on it, and we recruited a lot more people. We have fabulous contacts through the Berkeley Center. There's over 600 members. So we started brainstorming on who we thought would be good additions. And then I did a little bit of internet research for a couple of people in areas where we didn't have any personal contacts. And then we also asked our members for suggestions for other neighboring countries. That's how that initially worked. Very early on, David and I agreed that we wanted to do some intersectional chapters. So, the idea of how is harassment of women affected by somebody's race or their disability or their sexual orientation, or their class, or their caste, religion, race. So we solicited authors to write about the issue from looking at it from another lens. And then the brain trust that is the UC Berkeley Law faculty, David started talking up the book to his colleagues, and pretty soon we ended up having chapters on non-disclosure agreements, corporate governance, symbolic compliance, where you're just having people check the boxes, but they're not really making a dent on what kind of harassment situation you have in a workplace. We have a chapter on workplace investigations by one of the premier attorneys in the country who's worked on this issue, who just happens to be David's sister, Amy Oppenheimer. And then towards the end, we David decided, and I totally agree, that we needed a chapter on defamation. And David wrote that last chapter as we previously discussed. So it was organic. We ended up having 48 authors, and in some cases because there were a couple people who worked on chapters, but it also represented the great breadth of the book that covers 6 continents and people from all over the world. Our website has a cool feature that some couple of Berkeley law students worked on, which looks like you're looking for a hotel and all over the country with little red teardrops. But if you scan your cursor over it, it shows you the authors and their names and where their professional affiliations, what universities they're working with, and gives you a sense of just looking at a world map of how many people there are all over the world. So David is giving you the website address, which I can't read, so probably you can't either. It's www.globalmetoobook.com. It's totally cool, and I'm claiming it's cool because I had nothing to do with it other than just being a cheerleader for it.
Yeah, absolutely. Everyone should go visit the website after they're done with this program. Of course,
It tells you how to order the book from Fastcase.
Right.
Of course, our publication plans were thrown a little bit of a wrench because of the COVID pandemic that happened as we were just finishing things up. I wanted to ask you, now that we're sitting here in September 2020, do you think there are any unique sexual harassment, assault, discrimination issues that arose out of or are still arising out of the COVID pandemic?
Well, if we include domestic violence or intimate partner violence within the category of sexual harassment, sexual violence, the data we're starting to see is that there's been a big increase in domestic violence for a variety of reasons. One being that people are stuck together often in small apartments or homes and sort of can't get out of each other's way. And people are anxious and frightened. And there's no opportunity or fewer opportunities for women to seek help because shelters are closed and because they may not even be able to get away from an abuser in order to make a phone call to seek help. So for a variety of reasons, we're seeing an increase in domestic violence. I don't know in terms of sexual harassment in the workplace and sexual harassment on campus, but it may be that it's simply too early to know.
That's true all over the world, that there's been an increase of domestic violence. The other way I think we're seeing it is an increase in cyberbullying. I mean, we're all stuck at home on our own, and how are we interfacing? How are we interacting with each other? We're interacting with each other online, like we're doing right now. You know, there's phenomenon of Zoom bombing when you're having a meeting where you end up with people interfering with your meeting. But in general, I think it's the harassment has just moved online. It's, you know, there isn't as much physical proximity to each other often, except for intimate partners. But there still is plenty of opportunities to cause mischief over the internet.
I'm glad you mentioned that as a current issue. Cyberbullying is, of course, a newer concept or a newer platform for that type of action. And speaking of looking to the future just a little bit, one of the questions that comes up both in the audience questions and for myself personally was, do you think that there's going to be another or a revitalization of an older movement given our current conditions and our current COVID issues? What kinds of movements are you seeing that will be growing related to any of these current issues? Do you think there's going to be a big wave regarding climate change, or a big wave regarding, I don't know, what waves do you see coming arising out of the current movements?
David?
Well, this now is pure opinion, which is to say that, you know, I have no particular skill at prophesizing the future. But yeah, I think that the Black Lives Matter movement is going to continue to grow. It is growing globally. I guess this isn't pure opinion in that I'm observing that it is growing globally in quite remarkable ways, and people around the world marching and writing about and ask students demanding more of their schools, and people demanding more in workplaces. And I think similarly, the movement for recognizing and dealing with climate change is growing. Although then I guess at that point, I'm just giving you my personal opinion when I say I think the movement against climate change is growing. I don't know that I bring any expertise to the question.
You know, COVID it's just so revealing of all the structural, racial, class inequalities of who it's striking and what kind of impact it's having. But one thing that certainly has been observed is how it's adversely impacting women, who seem to be taking on the majority of the childcare and obligations, and also instructional needs of children stuck at home, you know, who are trying to do online learning. And that's not really about sexual harassment, but it certainly is about inequality, which then women end up in subordinate positions when they finally do go back to work. The Berkeley Center, we've got a couple of subcommittees going, dealing with looking at COVID issues, looking at climate migration issues. And so we're planning on putting on some conferences about those two issues.
That's an interesting point. I hadn't thought deeply about that, about how the home environment, it seems very obvious now that you've raised it in, but that the home environment could very disproportionately be affecting working women in light of COVID. But switching gears, we have another audience question, which is, the reluctance of coworkers to testify in discrimination cases is a major obstacle to proving discrimination. Laws prohibiting retaliation do not assuage practical fears of adverse actions against witnesses. Do you have any suggestions about encouraging witnesses to come forward?
Well, the reality is that they very well might be retaliated against, and that's hard to prove. So then you end up having the original lawsuit with the women alleging harassment, and then you have these other workers who are, careers are getting stalled, etc. I have to say, I was an administrative law judge for a long time in my role as general counsel for the Fair Employment and Housing Commission, which is California's equality body, now renamed the Fair Employment and Housing Council. And I never heard a sexual harassment case in all the years that I heard them where the woman didn't end up losing her job. Often, I would reinstate I would order the woman reinstated, but then the employer would end up settling the case, give her more money, and have her go away, because they just saw her as a problem. They didn't want her back. They were afraid that if they ever tried to discipline her, she could file a claim of retaliation, or that was the sort of the standard thought process, I think, of attorneys representing employers. So it's a huge problem. It really is.
My own experience with this is from, I litigated these cases in the 1980s and early 1990s. And I worried about witnesses being subject to retaliation. And I discussed it with witnesses in terms of trying to be realistic and informing them that retaliation was illegal, and that we would stick with them if they experienced retaliation, but recognizing that it could nonetheless play havoc in their lives. It was my sense then that despite that risk, that most people had enough of a belief in the importance of the rule of law. They may not have described it that way, but nonetheless, enough of a sense of duty that, well, they might ask to be subpoenaed so that they could say, hey, I didn't have a choice here. They sent me a subpoena, or they served me with a subpoena. But that most people, in fact, were willing to step forward and talk about what they had seen, even though they were fearful about retaliation. And I think that generally describes how our legal system has operated, although I worry that in this era in which we are throwing out our norms and in which there is less respect among many for the rule of law, that one consequence may be that witnesses and others asked to participate in legal proceedings will be more hostile to doing so and less willing to do so. Because in the end, it's about civic duty. And if somebody who believes in civic duty is seen as being a chump, instead of being a person who recognizes the responsibility of living in a society governed by law, then the premise of the question will become even more true.
That does make sense. And actually connected to that as my next question, which is about the investigation of sexual harassment, especially in the workplace. Most of the time when there's been an allegation of sexual harassment in the workplace, a private entity comes in to do the initial investigation, a law firm, a private investigator, or somebody else who's considered to be a neutral third party comes in. And there's a number of recommendations in the book itself regarding some of the standards that these entities should meet, timeliness, due process, impartiality, confidentiality. But all of those standards sound more and more like the standards that we apply on criminal investigators, on the police themselves and other investigative units. Are there any particular lessons that these private entities should learn from the public sector? Are there any standards that these private entities should absolutely be upheld to? And what about some of the current pitfalls we have with the criminal investigators? Are these private entities also going to be subject to them?
Well, in some states, I'll use California as an example that I know the best because I'm here. The only people who can do workplace investigations, separate from something in-house, but where you're retaining somebody, are either attorneys or licensed investigators who are usually ex-cops. So those are the only two people, and they end up doing very different kinds of investigations. So it's become like a little mini industry here. And an organization that Amy Oppenheimer helped found, the Association of Workplace Investigators, has guidelines and then principles that they utilize to do investigations. And I think they're very good. And Amy and I and a number of other people with the Berkeley Center are now working on a toolkit of we're not calling it best practices, but we're calling it ways of doing a good workplace investigation. What I found interesting as we started working on it was what's used in other countries, because a lot of countries will have like a committee set up to do it, and it'll be made up of representatives from the employer and also representatives from employees. That's more common in countries which have unionized workforces, where they want to make sure that it's not just the employer's point of view that's done. Now, the workplace investigations that are done here are often very confidential. The investigator is retained by the employer, is providing a confidential investigative report, and depending on what that says, the alleged harasser may or may not get terminated, may or may not have been found to have, as far as the investigator could tell, have committed the harassment. And I was going to say one thing to correct what you were saying, Aaron. In my experience, depending on where you are in the food chain, lower level employees might often, if the allegation is at a fairly low level, the investigation very well might be done by the human resource department in a workplace. But as the level of the employee who's alleged to have done the harassment moves up, they often will bring in an outside law firm, and not the attorneys who are the normal attorneys representing the employer, but an independent attorney brought in to do the investigation.
So in chapter 1 of the book by Catherine MacKinnon, who has been the most important voice over the past 50 years or 40 years on the question of sexual harassment globally, she offers 10 critiques of the US legal system with regard to our law of sexual harassment. And the first is to this point. She describes the current system of investigations as a corrupt system, complaining that employers are allowed to investigate themselves without any transparency, and the law permits and encourages it, and this simply encourages cover-ups. Now, Professor MacKinnon is not one to mince words, and she is very critical of our current system. I think she intends it not as a criticism of the investigators, but of the system in which they operate.
We had another audience question that's very timely. I'm sure you're aware earlier this week there was an executive order issued by the White House related to, it was called Combating Race and Sex Stereotyping. I'm wondering if you had a chance to look over that order and some of the commentary that's arose around it, and if you have any thoughts on that order and what effect it will have.
I haven't.
Me neither, sorry.
No worries. You might be interested to read it after this.
Is this the order that prohibits federal money to be used for any kind of anti-harassment training?
Yes, it's related to diversity training. Yes. Moving on, another question related to sort of the birth of this Me Too movement. To what extent do you think that the celebrity involvement in the Me Too movement has been helpful versus harmful when it comes to the real boots on the ground legal and policy impact?
It gave a false sense of how easy it was going to be to solve the issue, because there was a moment there where very powerful people who seemed completely impregnable up to that point were deposed from high-powered jobs, right and left, including a U.S. senator who I really like from Minnesota, and powerful people in the media industry and actors, were suddenly out in Siberia. So that didn't last very long. I mean, it seemed like it lasted until the confirmation hearing for Supreme Court Justice Brett Kavanaugh. And then you really saw, it seemed like a 180-degree turn. But for all those women still in positions of where they didn't have any particular visibility or any power, I don't think for most of them they felt like there was much change. We heard about women working as waitresses or wait staff, farm workers, janitors in working in buildings at night where all the janitorial staff is female except the male supervisor, who often was harassing women if not raping them. And for those women, the California legislature, for example, really started to try to make a difference with some better laws. But if you weren't visible, if you didn't have a lot of money backing you and also publicity, things pretty much stayed the same, I think.
I don't know that we've been able to measure the extent that there's been a change. I think in the sort of the world of white collar jobs and the world of academia, that there's been a shift, but it's based on perception, not data. I think Anne's right that in many jobs, and particularly for low-wage workers, nothing has changed. But I also think there are lots of parts of our society where the headlines and the men being forced out of positions, not by lawsuits, but by complaints, and then companies acting to protect, either protect themselves financially or to protect their reputation. I think that there's been a change, but I can't give you data in support of it.
I would just add one thing to what David said. The chapter, we have a chapter on corporate governance written by UC Berkeley professor Amelia Miazad. And one thing I found very noteworthy and interesting in her chapter was insurance companies waking up to reputational damage and investors waking up to reputational damage, so that they wanted some guarantees that they weren't going to end up having a problem, have to pay out a lot of money. If somebody had a lot of complaints against them, why weren't they just getting rid of that person? Why were they leaving them around? So it was going to cause more difficulties. So that seemed like a shift. But you know, I would definitely echo what David said. This has been more of a white collar phenomenon than a blue collar one.
Insurance companies play a very important role in legal compliance, because if they're insuring against a particular risk, it's in their interest to figure out ways to reduce that risk. And so if an insurance company is going to protect the company against the risk of sexual harassment suits, the insurance company is going to want to figure out, how can we reduce our exposure to liability here?
Well, speaking of business exposure to liability and the headlines lately, one of the concepts that's been coming up quite a bit lately has been non-disclosure agreements. And these are one of the potential serious vectors for abuse in the current system, especially if there's a large gap between the financial resources or social profiles of the individuals that are involved. Can you speak to a little bit to the use of non-disclosure agreements in both business and generally in the legal process? And are there any restrictions or criteria that you would recommend for them to prevent them from being such a vector for abuse?
We had one of our authors, Eileen McColgan, who is a barrister in the UK and an expert on this issue, write her chapter about the UK, and really highlighted this as an issue. We had asked our authors, you know, trying to make the book accessible not only to lawyers who are willing, you know, nerdy lawyers like us, willing to go through all the law, but we really wanted anecdotes. And the anecdote she picked was an assistant to Harvey Weinstein in the UK, who had been harassed by him, but had been forced to sign an NDA, which all of his employees were forced to sign as a condition of employment. She hadn't filed any complaint, and it wasn't a condition of a settlement. It was a condition of her employment, not to allege all of the horrific stuff that she both observed and also personally experienced. So Eileen had given testimony before the British government to try to change this. And as I referenced earlier, it's still kind of sitting around. Nobody's done anything with it. Her testimony was brilliant, but and it was definitely an issue. NDAs were definitely an issue here. It was sort of a part of the Weinstein playbook to keep anybody from talking about what had happened to them by Harvey. And so at least at the local level, in California, for example, the California legislature really took on NDAs and amended the law to make it much harder to utilize them unless it seems perfectly voluntary between both parties and at the end of a settlement in a lawsuit where the woman is represented by an attorney. But nothing's happened federally or nationally, and it's still an issue all over the place.
You know, when I started practicing law, and the first case that I settled in a discrimination case, and the defense counsel insisted on a confidentiality agreement, a non-disclosure agreement. And I was shocked, because I thought of this as a public process with a public end that would be available to anyone. And then over time, I think I was corrupted by the system, in that I began to like the confidentiality and NDAs because it made it easier to settle a case. It was something that we could give a defendant that the defendant wanted, that was important to the defendant. It was less important to the claimant. And now that I don't actively practice, still a member of the bar, I hate them. I do think that it's a public process and that people should have to live with the consequences of the settlement of a lawsuit, and people can say this is not an admission of liability, but nonetheless, I think that we harm others, we avoid protecting others by not disclosing the fact that claims were made and settled, because I think it puts people on notice about risks that otherwise are hidden. And I hate them in tort law, and I hate them in discrimination law. And, you know, I have the luxury of saying that as somebody who doesn't rely on the practice of law to make a living. But that's my view.
When I was serving as an administrative law judge for the state, one of the cudgels I think that the DFEH could point to if the case was going to go for a hearing before us is we were going to issue an order requiring them to post something, you know, basically saying mea culpa, you know, we've done this, and, you know, making it available for other employees to know that they'd been harassed. Now, whether they were actually putting them up in you know, someplace where they weren't immediately torn down after the inspector came through to see if they were there, I don't know. But it was one way of getting the word out. You know, in conversations I've had with younger activists working on this, you know, I was talking about, I was an undergrad at UC Berkeley, and in the women's bathrooms, there used to be, women would write on the walls, you know, watch out for Professor so-and-so. He's got, you know, he's got hands that are, you know, going to grab you or whatever. And that was the way we communicated with each other about harassers out there. And now with the internet and, you know, Twitter or whatever, there's more effective ways and efficient ways of getting the information out there. But it's, yeah, I'm not a fan of NDAs either. And I really laud California legislature for basically getting rid of them, except where they seem entirely voluntary at the end of a settlement.
Well, believe it or not, we're actually coming to the end of our time together today. So I wanted to thank both of you so much for your time this afternoon. I'm sure there's many things you could be doing on a lovely Friday afternoon, but thanks for spending it with us and our audience. I know everyone appreciates it. And I just wanted to ask if you had any closing thoughts on, you know, why people should buy the book or anything else that we didn't cover during our talk today.
Buy the book because all of the proceeds go not to Anne and myself, but to the Berkeley Center on Comparative Equality and Anti-Discrimination Law. And we really would be thrilled to have your support.
And I would say buy the book because not only is it a good read with all kinds of interesting examples, but it will give you ideas. It will get you out of your small box of what you think is possible, of other ways to approach this problem. It will help your litigation practice if that's what you do.
Thank you from the bottom of my heart. It's been a fantastic session today. And I just wanted to remind everyone our closing housekeeping announcements. There will be a copy of the recording for today's presentation sent via email to all registrants for today's session. If you have any questions about how to purchase, the Global Me Too book website is currently on your screen, but you're also welcome to email Fastcase directly. Our email address is support, that's SUPPORT @fastcase.com. And you're also welcome to email Fastcase if you have questions about some of our other books as well. We have a number of them that are on really great topics. And if you have any questions about Fastcase generally, please reach out to us as well. Thank you so much for being a part of our Leaders in Law series. And please, if you have any questions about Leaders in Law or other presentations, reach out to the Fastcase team. Have a great afternoon, everyone.
Thank you.
Thanks so much, Aaron.